The advisory opinion of the International Court of Justice, or ICJ, published on July 19, is a travesty which starts with its very title, Legal Consequences Arising from the Policies and Practices of Israel in the Occupied Palestinian Territory, including East Jerusalem. This is a travesty because in order to be occupied, a territory must have had a previous and recognized sovereign. From 1949 to 1967, the Gaza Strip was controlled by Egypt and the West Bank by Jordan. Jordan annexed the West Bank and East Jerusalem in 1950, but that annexation did not gain international recognition. Only the UK and Pakistan recognized Jordanian sovereignty over the West Bank, although the UK did not apply that recognition to East Jerusalem. So, Jordan was not a recognized sovereign before Israel took control of that territory by exercising its right of self-defense from Arab aggression in June 1967. By taking control of the West Bank in 1967, Israel recuperated a territory that had been designated for Jewish national self-determination by the San Remo Conference of 1920 and by the League of Nations mandate of 1922. Israel also reunited with its historical homeland, where a millennium of Jewish sovereignty was ended by the Roman Empire in the 1st century, followed by the colonial conquest of the Arabs in the 7th century, of the Crusaders in the 12th century, of the Mamluks in the 13th century, and of the Turks in the 16th century. So the West Bank is not, legally and historically, an occupied territory. It is at most disputed. But since when is it Palestinian? Palestine is a British colonial invention. Under the Ottoman Empire, there were administrative districts called sanjaks, named after Jerusalem, Acre, and Beirut. The British and the French dismantled the Ottoman Empire after World War I by dividing the Middle East along straight and arbitrary borders. They established new, artificial, and incoherent entities such as Iraq, Syria, Lebanon, and Palestine. In 1947, the UN suggested to partition the British mandate between a Jewish state and an Arab state. It didn't say a Palestinian state because nobody at the time had ever heard of a Palestinian people. When Jordan conquered the West Bank in 1949 and annexed it in 1950, it called it Cisjordan. Indeed, in French, that territory is still called Cisjordanie. It was considered a Jordanian territory then. Even the UN itself didn't call that territory Palestinian at the time. Between 1967 and 1976, UN General Assembly resolutions would refer to the West Bank and Gaza as occupied Arab territories. Only in 1977 did UN resolutions start using the expression occupied Palestinian territories. This was the outcome of the PLO's growing influence at the UN, thanks in part to the Soviet Union, the same Soviet Union that had established the PLO in 1964, 3 years before the West Bank and Gaza came under Israeli control. As Judge Julia Sebutinde, the vice president of the ICJ, wrote in her dissenting opinion, the court has misapplied the law of belligerent occupation and has adopted presumptions implicit in the question of the General Assembly without a prior critical analysis of relevant issues. The PLO and its allies may have made a tactical gain with the ICJ's non-binding opinion, but they have also further discredited international law, politicized UN institutions, and undermined the trust of Israelis in an honest partner for peace.